Welcome back, everyone, to the show. I'm very happy and pleased to have my attorney colleague, Russell D. Knight, with us. Thank you so much for joining us again. He's an expert in international family law. He has practiced thousands of cases already with international clients, especially in the US. He has practices in Illinois and in Florida, and he has 2 decades of experience as an attorney. Thank you so much, Russell. How are you doing?
I'm well, thanks. Thanks for having me again. This is always fun.
Yeah, so today we want to jump a little bit more into the emotional side of international law, right?
Mhm.
We as attorneys, we represent clients, a lot of international clients also that have high conflict divorces, right? So that means not only financially high conflict, but also emotionally and mentally, very draining. How would you guide as a legal representative, first in your profession, how would you go through those kind of divorces, right? And the second part of the question would be, how do you recommend your client to act in those kind of situations?
Well, high conflict divorces, in my experience, are usually the result of one party having a personality disorder, whether it's diagnosed or not. And then if that's identified, you can use some tools to figure out how do you manage that person's particular personality. But for most people that have a personality disorder, they're manipulative. That's part of the reason why it's high conflict. And so you have to create as much structure as possible. Does it matter if it's super high conflict and you don't have kids? Yes, but like when you have kids, it's impossible because you can't really get out of their hair and vice versa. So, what I'd recommend is to have temporary parenting plans or permanent parenting plans that are as detailed as possible. That way, you can always point to and say, like, pursuant to Article 7, Paragraph 3, Subsection 2, I'm supposed to pick him up with his backpack on Tuesdays at 2 p.m. And so that's what I'm doing. And then, God forbid, the police get involved or some other authority gets involved, that they'll say, well, it says that you have to do exactly that. And the people who are conflict prone, they hate rules. They hate it. They want to fight. They don't want to point to rules and say, okay, well, this is a reason not to fight. So that's my initial recommendation is to make it as rule heavy as possible
Mhm.
by agreement. And if not by agreement, you can do it by getting a court order. But in Illinois, for example, we understand that the courts are very busy and don't really want to determine what day you have to bring a kid's backpack to them, for example. So they'll appoint guardian ad litems during the divorce to investigate the best interest of the child and make recommendations, with the judges take wholeheartedly. It's always another lawyer, and they say, yeah, 2 p.m.'s, backpacks, that's what you're supposed to do. And then afterwards, if they remain high conflict, there's a person called a parenting coordinator who calls the balls and strikes. They don't make recommendations to the court, but they read the document, the final agreement from the court, and say, like, okay, well, this is what it says, and I'm saying that, in fact, that a bag with one rope on it is a backpack for the purposes of this agreement, and I'm saying that you should drop him off at 2 p.m. That's what it says, that's what it means, and if you need me to memorialize my decision because you want to take it to court, you can do that. So that's typically is the solution to high conflict, is to emphasize that you have to follow orders and the orders are as clear as possible, which means that lawyers really have to brainstorm about all the little possibilities that might come up, because the manipulative person, they're playing a game, and they, just like any game, they will read the rules of the game and they will use those rules against you. So you have to be completely familiar with the rules, and you have to make sure that there are sub rules and counter rules that will accommodate for when eventually the high conflict person will use the rules against you.
Yes, so what would you recommend a client that says, well, I'm, sticking to the plan, right? I follow your instructions, but I just don't get to, I don't get to agree with the other parent on any of the co-parenting plans, right? So I try my best. I
Mhm.
don't, force my children to say something or to do something, right? I stay pretty neutral, but the other parent gives me no choice. Like, would you recommend going back to court and inform the court about the behavior of the other party, or how would you go forward if you have your client's best interest in mind?
Yeah, so when it's especially for parenting issues, you do have to go back to court if you can't come to some kind of agreement, but there's a great way to do so. It's as old as the Bible itself. The story of King Solomon with the baby, when he said he'd cut the baby in half, and the real mother says, well, just let her keep the baby then. You have to be the bigger person, and when you point out that the person doesn't follow the rules, etc., you cannot get on your high horse. You cannot be, you know, signaling that you are the better parent. You have to say instead, I'm really worried about my kids. Like he does not provide consistency.
Mhm.
He doesn't follow these orders, and the whole reason the orders are there is so that the kids know that on 2 p.m. on Tuesdays, Dad's going to be there with a backpack. In the last 3 Tuesdays, that didn't happen, and so my kids are demonstrating anxiety. The
Mhm.
minute you mention I, and if you say I, meanwhile, I'm always doing it. I do it every single time. Don't I get a gold star, Your Honor? The judges don't care. The judges care about your kids. They don't care about you.
Mhm.
When it comes to a kid, you're the last thing. We were supposed to prioritize kids and do a good job with kids. And you certainly can point out the failings of your ex while not, not while simultaneously acknowledging that, yes, they're your child's other parent. They always will be. And we just need them to make improvements on their behavior rather than indict them for whatever horrible narcissistic monster they actually really are.
Yes, yes, perfect advice. So, what would you also recommend to clients that say, well, my kid doesn't want to have contact with the other parent, and you cannot really identify if that's the kid's wish, right? Or if that's
Yeah.
something that the parent installs in them and just tries to, like black paint the other parent all the time or
Mhm.
try to create a stigma, right, on the other parent. How would you, try to convince or like in a professional way, right? Your client to say, well, you better get your kids dressed, pack your bag,
Yes.
and get to the other parent, because otherwise the judge will do so, right? Because
Yeah.
we see it in a lot of female clients. If they say, well, the father was never there, we tell them the father still has a visitation right,
Yeah.
right? So you cannot, erase him as a biological father. It doesn't matter if he was not in the picture before, you still have to prepare the kid, right? And drop off the kid. It doesn't matter whether the father is living, you have to arrange that, right?
Yeah.
How would you also see when you have resistant clients that are not following that advice, that are still, trying to risk what they already have in court? How would you try to convince them in a professional way?
Well, I really think it depends on the age of the child
Mhm.
because when a child is 7, for example, that's sort of when a kid, has his own consciousness or starts to. And if they say, well, I don't want to see dad, no child is coming up with that on their own. We all know it. They're hearing that from somebody else and then repeating it. So you say, like, well, listen, that's a big problem because it makes you look terrible if you have a 7-year-old who says they don't want to see dad. No, what kids want to do is even if they don't know their dad, they want to be part of the families that they see on TV. They have a mom and dad, and they want to experience that. There's no question. Every single kid does. Now, when a kid gets older, let's let's say 16, and tell my clients, well, yeah, I get it. Like the kid probably is making decisions on their own. What can you do to make it look like you're facilitating it? Can you, pack the backpacks to go to dad's house and get in the car and take a picture of your 160-pound son, who there's no way you could possibly force to get into a car and deliver to his father. And if the son is frowning and if the son is like upset, all the better. Like the truth is that judges are not going to force a
Mhm.
person who, just a few months from now could probably join the army and die for his country to go visit a parent. That's just not happening. And then
Yes.
we have the special situation of what those kids that are in between. What do you do with a 14-year-old girl who's really passionate, upset with her dad, and or an 11-year-old boy who's big, but he's not cooperating either. And that's just too tricky. The only thing that you can do is to find a neutral ground. We usually call it reintegrative therapy,
Mhm.
where there's a therapist that specializes in this that say, you're not seeing your dad, you're seeing me, I'm the therapist. And I'm gonna have you come in. I'm going to talk to you on day one about how your dad's not in your life, how that makes you feel, and what I believe is the situation, which is probably not that your dad has chosen to abandon you, but that life is very complicated and dad's trying to do the right thing right now. And would you be open to that? And the kids always say, yeah, well, maybe. And then the second visit happens where the therapist then says, like, reintroduces the child to the dad, whether it's been 6 months or years or what have you. Everybody cries. The therapist makes it a safe space to say, it's okay. You're still allowed to be mad at the situation. You're still even allowed to be upset at dad, but we can't be mad at a future that hasn't happened. And this future might include, being in each other's lives. And it's not certainly not going to hurt anyone because we're all here today. And there are way that we can make this work in the future while still acknowledging the past. And most kids are really open to that. Sometimes it doesn't take just one visit, sometimes it takes six, but
Yes.
that is the expensive and time-consuming process. So it's part of why I tell dads, you can't disappear for a while because kids are mad at the parent that is gone. It does not matter the reason why.
Yes. Yes. So what would you tell clients that there can be a lot of women, but also men that are in this position that say, well, the other parent has never taken responsibility financially, mostly,
Mhm.
right? So I'm not gonna, get in contact with this person, and I'm not gonna be, friendly and reestablish a relationship for my child because I told my child, or my child knows this person has never, taking the share, right, for
Yeah.
this child. And you have to, of course, tell them, well, there are two separate things, completely separate things, right?
Mhm.
Visitation rights and alimony, all right, for child alimony. So it doesn't matter, right? If someone, of course, it's in the U.S. It's a you can go to jail, right? Not
Yeah.
a
Oh,
not
yeah.
not a very few people go to jail actually for not paying child support. But also on the other side, you are not allowed to connect these two separate matters. How would you convince someone to still tell them, well, before you go to court, you try to better make an agreement with the other parent?
Well, um, first of all, if the person isn't providing financially, like the other parent has every right to be furious with them. So I would acknowledge that it's not right and they're correct. But I don't go with that much into the idea of there's a complete dichotomy that because a person hasn't provided financially, that you should just forget about that, then reintroduce the child.
Mhm,
Usually I find that it's a big tell about the person. The type of person that is, whether they're financially or morally bankrupt, that won't pay for their kids at an
mhm,
appropriate rate. Usually those people are horribly irresponsible. And so the saying is you give them enough rope to hang themselves with. So you say, like, let's maybe talk about getting back in the kid's life. Were you willing to go to therapy for one session with yourself, one session with me, one session where the child's on his own with the therapist? And there's so many steps in between. The type of person who is so irresponsible or so short-sighted to not pay their support is probably not going to go through those steps.
yes,
If they don't go through those steps, your problem is solved effectively.
yes,
And then meanwhile, you can try to enforce the finances on the back end. So I would use their own inability to follow through as against them. And I think you'd have pretty good results. But at the end of the day, if there's a court order that says that the child has to see this person, even though he hasn't paid, you got to follow it.
yes. So just as a quick side note for women or for men, mostly it's mothers, single mothers who question how long back in time can I go to request child support for my kid that is already a teenager. Is there a time limit, and does it differentiate between the state of Florida and the state of Illinois?
The state of Florida and Illinois, if you have a motion for child support or something on file that asks for it, your right to child support is preserved from that date.
Mhm,
Now, if you're married and you file for divorce, you can't go back in time because like, maybe the husband abandoned the family, and the court will say, well, you should have filed for divorce a lot earlier than that. So they won't allow that. And then the rule of thumb is if you file but you still live together, like there's no child support if you're still living in the house and paying the bills. And then for parents that weren't married in Illinois, the court may go back in time to say, well, I know we served him in 2025, and I'm gonna go back in time to 2018 because otherwise, the type of gentleman that doesn't want to pay child support will simply run away from being served because they do have to be served and provided notice. And the truth is, until they recently allowed you to serve people via email, it
mhm.
was pretty easy to duck service. You could
Yes,
just leave for your house from your garage every day. They can't throw documents at your car.
yes. Yes. Okay, perfect. So what would you tell clients if they say, well, I want to go to court. I might not have the financial means, but I need to hire you as an attorney because you have the experience, right, into states, right, and extensive experience. You publish a lot of blogs as well, right, and a lot of, content, free content for people that are interested in. What would you tell them, right? They need to get in touch with you, and they obviously want you as their attorney. How can they get a hold of you, and what would be the next steps?
Okay, well, I tell people send me in. At this point, I usually talk to people on my cell phone, and then I say, text me your full name and your email. That way I'm in your phone and you're in my phone. So no matter what happens, you can always give me a call if there's an emergency. And people are very respectful. It almost never happens. And then I send them a contract and link to pay. And then based on what state they're in, and then we try to figure it out. If they're not getting paid by their former partner and they are in financial constraints because they need the money, there are tools that are available to me in both states that can allow for the former partner to pay me. But I can't let people walk away without, they have to have skin in the game. You can't come
Yes,
to
of
me with
course.
nothing. You got to give me some kind of money, and I'll set it up based on what's fair. So that way I know you're as committed to this case as I am. And
Yes.
then we go in and we get paid by the other side. But at the end, what often happens, I have to tell people, is the judges do not want to throw more gas on litigation. They're very hesitant to award attorney's fees
Yes.
because if you're going to get half a house, half a retirement account, don't expect to get attorney's fees on top of that.
Yes. Yes, but also like, and the slogan is always like high quality representation is expensive, of course, right? It's
You
like
get what you pay for.
exactly, you get what you pay for. So you cannot expect someone to take on your case, right? Because we have more than enough work every single day, right? You cannot expect an attorney to be passionate about your case and take it on and represent you and go. Mostly, it's also court cases. It's not just consult someone, right? You have to always go all in for someone, and of course, it's hourly fee or it's a retainer, right? Whatever you can offer this specific client.
If you had a toilet that was backing up right now and you called two emergency plumbers and one plumber said, I'll be there for $500 and the other plumber said, I'll be there for $750. There is no way I'm hiring the $500 plumber. I want the person that's going to solve the problem and is
Yes.
completely confident they'll solve the problem and knows what the problem is worth to
Mhm.
solve.
Yes, and the client knows, right? The
Oh, they
client
always
knows
know. Yeah,
that
they can smell if you're competent or not.
yes, and they know quality representation has always its price, right? So how can people get a hold of you? Should they contact you through your website
Yes,
first?
of course. They
Yes.
can. I've got a contact page. They can call my phone at 773-334-6311 or Florida 239-202-0455, and I'll be happy to chat with you or schedule an appointment.
Okay, perfect. That was amazing. Thank you so much, Russell, for this amazing talk again, and see you soon. And have a great weekend. Thank
Okay,
you.
great. Thank you.